Hear ye, hear ye. The United States District Court for the Middle District of Alabama is now open according to law. May God save these United States and this honorable court.
Welcome this weekend and this Monday. We celebrate the birthday of Dr. Martin Luther King Jr. And in actually February and March of this year, we celebrate the Selma to Montgomery March. That is the 50th anniversary, as well as the anniversary of the Voting Rights Act. As many of you know, this court played an important role during this time and in the life of Dr. King. And of course, the presiding judge of this court was none other than Frank Minnis Johnson, Jr. This court is extremely proud of that role. That is, today we are. And as part of all this sort of glorious celebration of Dr. King and the events that he inspired, we are hosting today this Freedom Rides Museum presentation of Judge Johnson, Jr. and the law. Joining me here today are two others, the most distinguished historian and author, Jack Bass, and a former Johnson clerk, Peter Canfield. But before we begin, I'd like to recognize a few special guests. First, we have Mr. Frank White, Director of the Alabama Historical Commission. Mr. White, and you will present some others, I understand.
Okay. Yes, thank you. Thank you, Judge Thompson. It is a real honor and pleasure to be in your courtroom. Over the years, we've had no stronger partner than the Freedom Rides Museum than the Middle District of Alabama. We gratefully acknowledge the many organizations that have supported this program and want to thank them. First of all, the Black Heritage Council of the Alabama Historical Commission, the law firm of Capel and Howard, the city of Montgomery, the law firm of Copeland, Franco, Screws, and Gill. This program will be the basis for an exhibit that will travel to local schools telling Judge Johnson's story to teach character and leadership. This afternoon we'll be open from 4 to 5, and Dr. Bass will be there signing his books, and we invite everyone, please come by for a visit. So thank you for your support. Both this courtroom, the Greyhound bus station, these are places that really matter. Thank you.
Thank you, Mr. White. Do we have any Johnson clerks here? If so, please stand.
There are two of us.
Ah, quite a number. I'd also like to recognize Ellen Mertens. She's really worked hand in hand with me on the bus station and this program today. Where is Ellen? You know, Ellen gives true meaning to the notion of historical preservation. Thank you, Ellen. And finally, I'd like to recognize, is our Chief Judge here? He said he was going to step in. He was otherwise engaged. Is he up there?
Debbie says he's in court.
Oh, there he is.
Okay.
I'd like to recognize our Chief Judge, Judge Keith Watkins. The reason he's up there in the balcony is he's a very modest man. However, let me assure you that that modesty does not extend to his ardent effort to preserve the history of this court. He is our chief, and he is our chief in everything, including this preservation effort. And I'd like to really thank him. Thank you, Chief. Now to the task at hand. I thought I would divide the panel discussion into 4 parts. First, we would get a 20-minute overview about Judge Johnson from Jack Bass, who perhaps knows more about Judge Johnson than any other living person. As we know, Jack wrote a stellar and thorough biography of Judge Johnson. Then we will hear from Peter Canfield for about 15 minutes. Peter not only worked for Judge Johnson, that is, as a clerk, but I think he became quite close to Judge Johnson as a friend. I won't say that he was Judge Johnson's favorite clerk because I know there are other clerks here. Once my own clerks asked me whether I would tell them who my favorite clerk was, and I told them that I would tell them individually, privately, and as long as they kept my response completely confidential. After Peter, I thought I would then talk briefly, maybe 10 minutes or so, in the role of a lawyer who practiced before Judge Johnson, as well as a judge who sat with him on a number of occasions. But to be candid with you, and perhaps most importantly, I thought I would speak as an average black Alabama citizen, albeit a young one at the time, about 8 years old, who witnessed from afar, but who was affected directly and deeply by what Judge Johnson did. Jack?
Well, I will talk about Judge Johnson. And I'll begin with his early life in Winston County, which many of you know is the Free State of Winston. It's where he grew up, where twice as many men served in the Union Army as the Confederate Army during the Civil War. Winston County had the fewest number of slaves and grew the least amount of cotton. And 2 of Judge Johnson's great uncles fought in the Civil War in the 1st Alabama Cavalry Regiment of the United States Army and rode with General Sherman. His father later became the first and only Republican in the Alabama legislature in the 1930s. And Judge Johnson later went to, well, in any event, but he went to law school at the University of Alabama. And in World War II, he served as an Army lieutenant. He arrived on the beach of Normandy 5 days after the first troops landed. And so after 5 days after D-Day, there were still American paratroopers hanging from limbs in the trees. So that's what it was like at that time. He got wounded once and went back for treatment and decided he didn't need to go to the hospital, and he went back and got wounded a second time. So this time he became part of the Judge Advocate General's Corps, but in France. He was later returned to Alabama, practiced law in Jasper in a small firm, and he became the U.S. Attorney in the Northern District of Alabama, and he was picked by Herbert Brownell, President Eisenhower's Attorney General and former campaign manager. And there was one person at the higher echelon in the Justice Department then, and he talked about how during lunchtime they frequently talked about Judge Johnson's decisions on the district court. President Eisenhower then appointed him district court judge in the Middle District of Alabama. He was the youngest federal judge in the nation. This was the fall before the bus boycott case in Montgomery. And when that case first came and there was an appeal to the federal court, Judge Johnson asked for a 3-judge district court. For those who are non-lawyers, that means you have 1 circuit court judge at least and usually 2 district court judges. And so they heard the bus boycott case, and once Judge Johnson asked one question, and Martin Luther King was there then, and he turned to an aide and said, these federal judges are a lot better than the state judges at that time. So Frank Johnson was later interviewed, I think it was for 2 hours, by Bill Moyers. And Moyers interviewed him, and he talked about that case. And he said that when you have one of those panels, the junior judge votes first so as not to be influenced by the more senior judges. And Judge Johnson said, well, I didn't have much to say. I just said, Judge, it seems to me that any discrimination based on race in a public facility is unconstitutional based on Brown versus Board of Education. Second judge was a well-known district judge from the Northern District of Alabama, and he disagreed. He said he thought that, you know, if there's going to, that sort of decision should come from the Supreme Court, not from a 3-judge district court. And so then Judge Richard Reeves, an Alabama native then on the, and who had practiced law in Montgomery, and he was on the old Fifth Circuit Court of Appeals, and he just said, well, I believe I agree with Judge Johnson, and that was it. He said it didn't take, said they just, they discussed the whole thing less than 15 minutes after all the testimony. And so that case typified Judge Johnson on the bench. You know, there was never any nonsense. He was always extremely well prepared. And I later learned, much later, from a friend of his who taught law at the University of Alabama Law School, and he had some, but he had taught, and he had some very complicated tax case. And he had about a 35-page brief and wanted to show it to Judge Johnson. And it turns out that Judge Johnson had the capacity to read a page at a time. I don't know how he did it. I wish I could do that. But he sort of kept turning the pages, says, I see you got a little problem with some section of the tax code here, or something like that. And Judge Johnson never was one to, you know, to put on airs. And so then the next really big case he had, there were a lot of significant cases, was the Freedom Riders. And at one point he had this brand new lawyer from the Justice Department. He'd been there, you know, less than a year, and he came down to sit, and the judge said, well, I'm going to need your help. And he said, Judge, I've never tried any kind of civil rights cases. But he told me that he said there were 22, in 22 minutes, the judge dismissed 15 motions by defense lawyers. And the lawyer who told me that said he had been in the Justice Department and had an appeal, a motion before a federal district judge in California. He said he's been waiting 4 years and still hadn't gotten a ruling on it. I want to read you just one little something here. Well, I'm going to get to that in just a minute, but I've got it. But then came the Freedom Riders case. And the Freedom Riders, you know, and most of you are familiar with the story. And the Freedom Riders Museum is next door, so if you're not familiar with it, make sure you visit next door to the Freedom Riders Museum. But there were a group of racially integrated people sponsored by the Congress on Racial Equality, known as CORE, civil rights group, and they rode in Greyhound buses John Lewis was one of the real leaders of that. And so when he got to Alabama, the John Siegenthaler, who was on the staff, he was like the public relations person, the media director for the Justice Department under Robert Kennedy. And he spoke to the then governor of Alabama, Patterson, who said he didn't think that the state could provide protection for them. And then he turned to Floyd Mann, who was head of the state police, and said, "Floyd, what do you think?" And he said, "Governor, I think we can protect them." So after many of the rioters got beaten by the Klan in Birmingham, and more came in, and so the state police gave him an escort right to the city limits of Montgomery, different police jurisdiction. And when he came to the bus station around the corner, there was a mob there, a lot of Klansmen and others, suddenly giving them all terrible beatings, and the police disappeared, the city police. And finally, Floyd Mann showed up, and he fired his pistol several times, but in the meantime, a lot of people got seriously beaten. John Lewis got knocked unconscious. Someone slammed one of those wooden Coca-Cola crates on top of his head. And when he was still sitting there half dazed, the then Attorney General of Alabama came up and presented him with this warrant. And so Judge Johnson had to rule in that case. But after Mann got there, then the city police came back and brought order. But a number of people were seriously interested, including Siegenthaler, who got slammed over the head with a pipe and was knocked unconscious. And so when the trial was held, Judge Johnson held a trial in Montgomery. And I want to read just a little bit from It says, in Johnson's courtroom, this courtroom, on Friday, June 2nd, after the hearings ended and the judge was ready to read his order, he hunched forward on his elbows and looked quietly at the parties in front of him, gazing from the Klan dragons and their lawyers to Public Safety Commissioner Sullivan and his police officers, to John Doerr and his Justice Department colleagues, to King and his fellow ministers, and then to the crowd that packed the courtroom. There was total silence except for the quiet hum of the air conditioning. Then Johnson spoke in a calm, firm voice that seemed to ricochet the words off the back walls. Quote, "If there are any other occurrences of this sort," he said, "I am going to put some Klansmen, some city officials, and some policemen and some Negro preachers in the federal penitentiary in Atlanta." His order not only enjoined the Klan groups from their violence and interference with interstate travelers and the Montgomery police from their, quote, unlawful, close quote, of, quote, willfully and deliberately failing or refusing to provide protection, but also enjoined Core, King, and others from continuing Freedom Rider activities. He went on, quote, "While it is true that this violence is caused directly by the Klan groups and others acting in concert with them and has been allowed by the willful failure of the police authorities to take the usual adequate protective measures, it is equally true that the Congress of Racial Equality, the Southern Christian Leadership Conference, Ralph D. Abernathy, and F.L. Shuttlesworth, and Martin Luther King, Jr., and others acting in concert with them by their actions in financing and sponsoring and aiding and assisting such non-bona fide trips are directly causing an undue burden and restraint upon interstate commerce with the state of Alabama. He continued, he said, although the freedom rides were, quote, within the law of the United States, Johnson said, they also represented, quote, agitation that constitutes an undue burden upon the free flow of interstate commerce at this particular time and under the circumstances that coexist in this state and district. He said, the right of the public to be protected from the evils of their conduct is a greater and more important duty. Although he said that CORE and others may be one of their legal rights belonging to these individuals are the citizens of the United States. And as Mills Thornton has written, that Judge Johnson seemed to change after the freedom rides to some extent, and really realized that it would take that law and order was the absolute core of what must be protected, and all constitutional rights that must be protected. And then in later in Lee versus Macon County, a case that went on for years. This has never been, what I'm going to tell you, has never happened before in American judicial history, nor has it happened since. You had Burke Marshall from the Justice Department came down, and Judge Johnson had this case that from Macon County. And then Burke Marshall wanted to, they had other school desegregation cases in the Northern District of Alabama, in the Southern District of Alabama, and he wanted Judge Johnson to try and get judges from those districts to all combine into a single order. And the judge said he was willing to do that, but he was not willing to ask the other judges to do it. So Burke Marshall contacted 4 other judges, 3 from the Northern District, 1 from the Southern District, to join in a 5-judge district court, of which there's never been one, I say, before or since. And it took a long period of time. It took years for it to fully implement, but they eventually did it, and so Alabama ended up with, in effect, a statewide school desegregation order done not by the Court of Appeals or the Supreme Court, but by the district judges in the state. And that's just another example, I think, of the type of leadership that he displayed and the full confidence he had from the Department of Justice. And by this time, Judge Johnson had federal marshals guarding him 24 hours a day for 15 years, and he never lost any sleep. And then there's Selma. And many of you, I expect, have already begun to view the movie. I know it's just come to Montgomery. And I saw it last Sunday. And you know what, the key to it all, Judge Johnson had not seen the bloody Sunday march when the marchers were beaten and turned away and beaten by both the highway patrol and the sheriff's posse in Selma on the bridge, on the Pettis Bridge. And he told that to John Doerr. That was also during that trial was the only time there was any actual out-of-court interaction between Judge Johnson and Martin Luther King. They went down on a crowded elevator together from here, probably from this courtroom to the ground floor, which courtroom it was. And Judge nodded at Dr. King, said, "How are you, Dr. King?" He said, "Fine, Judge, how are you?" And that was it in terms of direct personal contact between the two of them. And so then, after 4 days of hearings, and John Lewis was sitting in the courtroom. He was the first, he thought he'd had a fractured skull when he was slammed over the head with by a highway state police in the first march. But he was back in the courtroom. They first thought he had a skull fracture, but he didn't. But he was in the courtroom, and he told me he was watching Judge Johnson when at the end of the trial they played the video of what had happened on the bridge. And John Lewis said, I could tell, and Judge Johnson was writing very furiously and with a certain look on his face that John Lewis said, I knew from the look on his face that he was going to rule for us. And this is where the movie Selma misses something. There's Martin Sheen plays Judge Johnson in a very cameo role, just citing one line, but don't explain it very much. But Judge Johnson wrote his order, but he wrote it only after getting, after the NAACP Legal Defense Fund counsel, Jack Greenberg, and a couple of others spent most of the night writing the entire plan for the march, where the marchers would spend each night, where food would be, where rest stops would be, that there'd be no more than 30 marchers in one single group on the highway, and at least 50 or 100 feet, whatever it was, between the marchers, between each group of marchers. And then Judge Johnson then wrote the order allowing the march, and he shows it to John Doerr and says, here's my order. I will not issue it unless I have assurance from President Johnson that he will enforce it. He was not trusting Governor Wallace. Even though he and George Wallace had actually been close friends in law school and even double dated together, but that was a long time earlier. And so Doerr dutifully reports this to Attorney General Katzenbach, and Doerr reports back. He said he talked to Attorney General Katzenbach, and he said the order will be enforced. And Judge Johnson says that's not good enough. So Katzenbach calls back 20 minutes later and says, President Johnson says it will be enforced. And then he issued the order. And there was no legal precedent for what he did. He applied the principle of proportionality, and this had never been done before in the federal courts in the history of the United States. He took the principle of proportionality. The more serious the crime, the greater the prison sentence. The more damaging the injury, the greater the award in a civil lawsuit. And he applied it to constitutional injury. And he told me once, he said, if it had been like 50 people marching, that wouldn't have justified it. But he said, here you had a whole race of people seeking to protest what was a great injustice. So he issued the order, and then George Wallace Jr.'s op-ed yesterday, if anybody, for those of you who read it, has a few facts wrong in it. He said that Governor Wallace called President Johnson to meet with him. Actually, after President Johnson said the order would be enforced, he called George Wallace to Washington. And Wallace, Burke Marshall, who was there as an observer, he had just retired from the Justice Department, but he told me, he said Lyndon Johnson, the full force of his overpowering personality, that and by the time Wallace got back to, Governor Wallace got back to Montgomery, he decided that the state couldn't afford to provide the protection and let the White House know, and at that time, President Johnson then federalized the National Guard of Alabama at a cost of several $1 million, as it turned out. But the movie doesn't show any of that part of it. It has, and then Johnson, at the end of the march, who he recognized that the climate, I mean, it was like the whole country watching this public morality play for 4 days, or 5 days, whatever the length of the march was. And then he goes before Congress, makes his speech about the Voting Rights Act, and concludes it by saying, "And we shall overcome," the anthem of the Civil Rights Movement. And Congress passes the Voting Rights Act. So Judge Johnson then had a couple of other cases. He had one on Wyatt versus Stickney, which was about mental health treatment, and Newman versus Alabama on prison reform, in which he, in his courtroom, he heard these really terrible stories about both agencies and the treatment.
For my first day of work as Judge Johnson's 32nd law clerk. It's also a pleasure to be here, of course, with Judge Thompson, who I had the honor of clerking for immediately after my clerkship with Judge Johnson as his first clerk. And of course, to be with Jack Bass, who has studied the judge for so long. It's also wonderful to have here in the audience so many former Judge Johnson clerks, including my wife of over 30 years, Laurel Lucy, and my son Patrick. Laurel clerked for the judge. She was clerk number 43. And Deb Ellis, who was clerk number 41, who at the request of Judge Johnson as one of her last clerkship assignments introduced the two of us. So I owe more than most to the judge. I'm sorry. I've been asked to do my best to give you a sense of what the judge was like for those of us, his law clerks, who had the good fortune to work with him on cases in these chambers and courtroom. Professionally, the judge gave us clerks the best gift you can give a new lawyer, an understanding, the deep understanding that he had and lived of abiding respect for the law and the courts, and a sense of the obligation that he felt so deeply to preserve and protect them. The judge didn't teach us this respect by lecturing us in the way we were used to in law school. In fact, in the 20 years I knew him, I cannot recall ever hearing him lecture anyone. At least it never sounded like a lecture. He did give orders occasionally. But to give you an example of how he would teach, as a law clerk, you're working on opinions, you obviously need to make sure they're right, and you have to be very careful. Justice demands it, and the parties are entitled to it. So how did the judge convey that to us on our first day of work? Well, to me, he did that by telling me that in drafting an opinion, I needed to proceed as porcupines do when they consider sexual intercourse. Very carefully. And that gave me the idea. Clerking for the judge was like becoming part of an extended family, a family that included not only the judge and Mrs. Johnson, but so many others in the courthouse. And it included occasional dinners at their house, dinners at which the judge and Mrs. Johnson would actively encourage us all to come out of our shells by, for example, telling a story, which the judge loved to do, or writing and reciting a poem, which Mrs. Johnson loved to do. And they took tremendous joy when we would follow their lead and do that. It also included, when we were lucky, fishing trips with the judge, working with him on woodworking projects, building clocks and those sorts of things. All those times were important times for him to get to know us, and us him, and develop, as I know we all did as clerks, our special bonds with he and Mrs. Johnson. And he had the same sort of times, I could tell, and developed the same sort of bonds with other court staff, and certainly when he joined the appeals court with his colleagues on the 5th and then the 11th Circuit. Humor played a big role in those times. Humor and the judge's tradition in saluting the Constitution with a drink of whiskey in the evening before dinner. And we all benefited as part of feeling we were within that family from the judge's remarkable candor with his clerks. It wasn't that he felt like he needed to regale you with how to practice law and tell you stories all the time. To get him to teach you, you had to sort of raise the subject just right, and if you did, he'd share his observations about the work of other lawyers and judges, including his own work. But in addition to what he told us, where we really learned respect for the law and the court was not from what he said, but from what he did. And that was really in all cases, not just the important ones, the so-called important ones, because he felt all were important and at all times. What I believe we all found virtually from the moment we arrived here was that Judge Johnson was in a league of his own in terms of just pure judicial craft. In preparation for today, I was rereading Jack Bass's chapter on the Freedom Rides, and particularly its description of a meeting at which a Justice Department delegation of Robert Kennedy, later to become a Supreme Court Justice, Byron White, and Burke Marshall, went to the White House and explained to a very concerned President Kennedy how they intended to protect the Freedom Riders and why in doing so they planned to get a case in front of Judge Johnson. They explained to JFK that it wasn't because Judge Johnson was considered biased in civil rights cases, he was not, or because he was fond of demonstrations, because he certainly was not. It was because Judge Johnson was, as Burke Marshall told the President, and this is the quote, clear, straight, and quick. And that he was, and it was apparent to anyone who had contact with him in this courtroom. We clerks, and at the time of Selma and the Freedom Rides, there was just one clerk, but when I clerked, when he was on the appellate court, there were three of us. We'd spend days in the library agonizing over memoranda and draft opinions that were just a small percentage of the court's workload. Meanwhile, Judge Johnson would be reviewing cases and drafting and issuing orders and opinions at a prodigious rate. To be honest, after a very short time, we all knew that he could have done it all by himself more quickly and correctly. I clerked for him on the Court of Appeals, where most issues required a concurrence from at least one other judge, and that could obviously be time-consuming. When he was on the trial court, where he generally acted alone, I think his efficiency, it's fair to say, was legendary. Most judges will hear a case and then cogitate on the evidence and argument for several months before finally issuing an opinion. Judge Johnson would do that in some cases for sure, but he was also well known, even in some very long and complicated cases, for taking a brief recess on the final day of trial and then returning to the courtroom to dictate and announce a cogent and persuasive decision. Being around Judge Johnson, you quickly learn that he did not miss much, if anything, ever. Not at the office, not when you were with him at his house, not even when you were on a fishing boat out in the Gulf. I can't emphasize that enough about him. You just knew when you met him that this is a person who understands what you're up to. Even if he didn't call you on it at that time, you had this feeling that he knew. Many people have said how many people found Judge Johnson very intimidating. And that's why, not because he tried to be intimidating, I don't think he did, but again, you just knew that you weren't going to be able to put one over on him. You also learned that he did not say or do anything by accident. He always thought out what he did before he said or did it. And if he said it, he meant it. He wasn't long-winded in his opinions. To the contrary, in his opinions, as in his speech generally, he believed in expressing himself simply and directly. He would tell his law clerks that he didn't want us writing law review articles, and he certainly didn't write his opinions so that they would be written up in law reviews. Eloquence was not his goal, clarity was, and that was achieved with plain and unembellished language. He was not one for making symbolic statements, and he did not view his opinions as vehicles for those. He did think that writing simply and directly in a manner intelligible not just to lawyers but to the public was important to developing respect for the court's decisions, which was necessary to ensuring compliance with them in the long run. He believed that the parties in cases and the public, particularly in the civil rights decisions, should be able to read the decisions and understand why he came out the way he did. I remember him quoting Griffin Bell, the Fifth Circuit judge from Georgia who became Jimmy Carter's Attorney General. And he said that speaking of the judge's writing, Judge Bell had told him, "Frank, you're not an artist. You write more like somebody painting the side of a barn, but you get the job done." And I think the judge liked that. The last thing Judge Johnson ever wanted to do was issue a decision that declared rules and principles that would not be enforced, that would weaken the law by encouraging disrespect. Accomplishing that was, I believe, a big part of his judicial genius. He was able to accomplish it in small ways every day by the way he ensured order in his chambers and courtroom. I remember him saying that he felt like it took him at least 5 years on the bench before he could really control what happened in the courtroom, but there was certainly no doubt that he had mastered that. And in big ways, in his decisions, when by virtue certainly of those big institutional litigation decisions, he was in effect running most of the major institutions of the state of Alabama, he was always most careful about making sure that he was doing things that actually accomplished results. Although the judge could certainly be an intimidating figure, and certainly by the time I clerked for him, he'd achieved considerable acclaim and fame, he was, as Jack Bass said, never pretentious. He never asked for nor expected any kind of special or red carpet treatment. Quite the contrary. This was before my time, but he even did not wear, when he first became a judge, he did not wear robes or use a gavel in the courtroom until he was ordered to do so by the appellate court. He thought that was too formal. He seldom moralized at sentencings, at least in open court. He let his sentences explain themselves. He wasn't aloof from his law clerks. He had the most highly attuned sense of humor of just about anyone I've ever met. More on that in a moment. But he did not believe in putting humor in court decisions. He thought that was disrespectful to the litigants. I think some of that got into his later Court of Appeals decisions, but that was probably more the fault of his clerks than the judge.
It's always the fault of the clerks.
He also did not believe, as some judges do, in nursing his judicial reputation. That's not to say he wasn't proud of it. He was very much so, but he didn't shy away from controversial cases in order to protect his reputation, as you'd sometimes see judges do, and he didn't pick cases as vehicles to advance it. He believed in deciding the cases before him, and in deciding them not according to his moral views, but according to his view of the law. He had the most abiding sense of duty of anyone I have ever known. The judge would joke about how being a judge was just a job. And as he liked to say, on difficult days, which were more days when, on the appellate court, for example, the court was going in a direction different than he liked, he'd say, well, it still beats plowing. Or occasionally he'd say that if he felt like he did not have to back up to the paymaster this week, if he felt he'd done a good job. No one who knew the judge would ever say that he ever cut any corners to try to make life easy for himself. Far from it. He set very high standards, and those standards and courage that characterized all of his work for the court also governed his life outside the court. This may be trivial, but I can't, and it's with all the clerks here, I hope you will hear from them, as we all do whenever we get together, either in reunions or these days through email, wonderful stories that from the judge for many years. But to tell one, those who know the judge by his well-deserved reputation of a tough-as-nails jurist are often surprised to learn that, again, he was not a prude, he was not pompous, he enjoyed poking fun, particularly at pretension, and he didn't mind being poked at in return. I got an introduction to some of this humor just probably the second week of my clerkship. The full Fifth Circuit was in session in New Orleans, and when we were in session in New Orleans, the judges got a government rate at the Royal Sonesta Hotel. So the judges would all stay on a certain floor of the Royal Sonesta. And to this meeting that Judge Johnson had brought from Montgomery what was left of a half-gallon bottle of Jack Daniels for saluting the Constitution. And when the judge and a few other judges and clerks and I had emptied it one evening during the cocktail hour and were headed out for dinner, the judge had me place this empty half-gallon bottle of whiskey next to the dinner dishes that were outside the door of the chief judge of the court, Coleman. Chief Judge Coleman detested New Orleans. He made no mistake about it, and he often retired very early. And that night, I'm sure every judge on the court had to pass his door and wonder what state he would be in the next morning.
Thank you, Peter. We're actually we're actually a little bit over time, and okay, go ahead, Jim.
Okay, one thing I forgot to mention that is important, though, was that during this Selma trial, it was at that time that Martin Luther King, and this was reported in the New York Times, he told the judge's law clerk, he said, Judge Johnson is the man who gave true meaning to the word justice.
Thank you. As I said, we've gone a little bit over time, and I'm going to cut short my remarks so that we can hear from you through your questions and comments. But I'd just like to just say a few things about my knowledge about Judge Johnson. I told you I practiced before him as a lawyer. I'm not going to dwell on that because I think there are many here who did that and probably have their stories to tell. However, I did serve on a number of cases with him as a judge. And in fact, I'd just like to briefly tell you about the first case I served on with him, which was appropriately a Section 5 voting rights case. And as the youngest judge of the three judges, Judge Johnson, Judge Hobbs, and myself, I had a number of questions. The first one being, how do you walk into the courtroom? So I asked Judge Johnson, I said, do I sit on your left or your right? And he said, Myron, I don't ever want to hear of you being on my right, always on my left. When we sat down to deliberate, it was a simple voting rights case, and I had had my law clerks do a number of, an extensive memorandum on this issue. I walk in, and of course, being the youngest judge, I go first. so that I am not influenced by the older judges, in particular Judge Johnson. And the issue was whether the fact that the city of Montgomery had all these police officers at black polling places violated Section 5, that had never happened before. And I had a 30-page memorandum ready there to read to the other judges, beginning with, I'm sure, the history of Section 5 of the Voting Rights Act. And I started into it, and Judge Johnson stops me, and he says, I just have a few questions for you, Myron. And I said, what? He says, in fact, I think I may have just 3 or 4. He says, did they have police officers, by the way, which were all white, at these black polling places before? I said, no. He said, did we hear anything in the trial that indicated that there was a need for these police officers at these black polling places? And I said, no. And he says, well, what do you conclude? I said, well, I think they were there for racist reasons. He said, so do I. What do you think, Judge Hobbs? I then pocketed my memo, and then he told me, he says, why don't you write something short to that effect? But that's the way he was as a judge. He was absolutely wonderful to work with. He also, on one occasion, because I know many of you think that he was very aloof, not a very warm person, but I had just had twins, and I walked in, and I had pablum on my coat jacket. And he said, is that pablum on your coat jacket? And of course I went, oh my goodness. And he proceeded to take it off with his fingers. He was just that warm and approachable. But I'd really like to talk just a moment, and really only about 30 or 60 seconds, about what he meant to me as a person growing up here in Alabama. And to me, that is the most important part of my memory of him. I grew up in Tuskegee. This was long before Dr. King. This is in the 50s, when there were only 2 persons' names which were mentioned with reverence. Those names were Dr. C.G. Gomillion and Judge Frank Johnson. If you grew up in Tuskegee, when you said those names, if you could not say them with the gravitas and sort of hushed silence of James Earl Jones, you know, it would be Dr. C.G. Gomillion and Judge Frank Johnson. You even had to have the depth to say it. You didn't mention them at all. That's how much reverence people who lived in Tuskegee bore for Judge Johnson. In my household, the mention of his name literally, was something that we never laughed about. And as I've often said, this courtroom, this courthouse, the 4 walls of this building, they were an oasis of justice. And what was in my small world as an 8-year-old, a world of total injustice. That was Judge Johnson to me. Thank you. I would like now to open the floor up for questions for us. Yes, Ms. Alice?
I think sometimes looking back on history, it always seems more simple than it really was, right? And like the Revolutionary War was really a ragtag thing. And sometimes we look back on Judge Johnson's work and we think maybe it seemed simpler than it was for him. And part of that is because of the kind of person he was, very matter-of-fact, very efficient. He didn't show indecision. But I want to tell a little story that I think illustrates the difficulty of what he did and illustrates his greatness. And really what I wanted to elaborate on is the Browder versus Gale decision, the Montgomery bus boycott case. He was a very young man when that was decided. And as you said, he spoke first. I had the opportunity in 1985 to interview Judge Johnson on Judge Seaborn Lynn for a speech I was giving for the Alabama Historical Society about that case. And I think Judge Seaborn Lynn's reaction about that decision is what's informative about how difficult it really was. Brown versus Board of Education was about education. the Montgomery bus boycott case before them was about transportation. There's a very old case that many of you might have heard of called Plessy versus Ferguson. Now, if you remember, Plessy versus Ferguson was about transportation. So the very nuanced take on that Judge Lynn had was, well, Brown versus Board of Education did not overrule Plessy versus Ferguson. And so, until the Supreme Court spoke, they, as the district court judges, have to follow the Supreme Court precedent. So I just wanted to add that, and also add that Judge Seaborn Lynn, when I interviewed him, was either in his late 80s or early 90s, and only had dissented, I believe, one other time in his entire life, his entire course of his career. So I just want to tell that story to again say that, of course we think the bus boycott decision should come out the way it did, but it wasn't so obvious in 1955, and it wasn't so obvious to this very senior district court judge, Seaborn Lynn, and I think again illustrates Judge Johnson's maybe inherent respect for the Constitution.
Thank you. Yes, please tell us who you are first.
Sure, Dusty Farned from Jones Law School. This question's for Dr. Bass, and I think it's interesting reading here that you had won the Robert Kennedy Book Award. And I just wondered if you could talk to us a little bit about Robert Kennedy Jr. coming to live with Frank Johnson. I think it maybe was one summer, and just kind of how that relationship, Kennedy-Johnson relationship, worked.
Well, this Robert Kennedy Jr.'s Ethel Kennedy, it was after Robert Kennedy was assassinated. And Robert Kennedy Jr. was in his teens, I believe, if my recollection is correct. And not 18 or 19, a little bit younger. And so she contacted somehow the Johnsons. I don't know the whole details. And anyway, they allowed, and that was not long after the Johnsons' own son, Johnny, who was adopted, committed suicide. And so he stayed with them, and it was very healing experience. I think probably for all of them. And then Robert Kennedy Jr. later wrote a biography of Judge Johnson. I mean, it was, you know, he was still quite young at that time, but it was it clearly was a useful exercise for him, and it was a useful book, but it was a useful exercise for him in just sort of working through, I think, a lot of emotional issues. And then when my biography of Judge Johnson won the Robert Kennedy Book Award, my wife and I and 3 of my sisters all went to Ethel Kennedy's with a number of other people for dinner that night. And but when the award was made, Robert Kennedy Jr., you know, he presented the award. So I think that more than covers it.
Let me just follow up on that. As many of you may not know, Jacqueline Onassis was actually one of the publishers of his book. And my copy has a card from Jacqueline Onassis in it, the one I have at home. I haven't brought it to the courthouse because I don't want anyone else to take it. But I want to ask you a question. How did the Johnsons react to your book?
The book had graphic detail because I got it from the source. I think it was George Dean, but I'm not sure. Someone who actually had to. I mean, what happened was Johnny borrowed a shotgun and, in effect, put it like, forget who the author was who did that, and pulled the trigger, and it was committing suicide and, you know, literally blowing his brains out. And he told me what had happened and so forth. And I think that the Johnsons had never really grieved. Judge Johnson's such a strong individual, an emotionally strong individual. They'd not gone through the grieving process. And so they were very unhappy because of that. And I learned that from a mutual friend. And so then one of the mutual friends said that she heard that Ruth Johnson was not feeling well. So I called to just ask how she was doing, and she said, well, I'm not really ready to talk much, but she said, but my sister did say that she thought what you wrote should have been in the book. So that was, Ruth was always very direct. And so the first stage of grieving is anger. And then there's a second stage and a third stage with different emotions dominating. So I waited and didn't do much. And then there's actually a statue of Judge Johnson in Haleyville. And he asked me if I would dedicate the statue, which I did. And then much later, when he got the Presidential Medal of Freedom from President Bill Clinton, his health wasn't good enough for him to attend, and he asked me to stand in for him. And then when he was on the 11th Circuit and he was in Atlanta on court, he took my wife and me out to dinner one night, and then we had visited them once in Haleyville as well. So but after he died and I drove to Montgomery, a lot of his law clerks were pretty hostile because they knew about the first part of it all. And so I went to the funeral, and then Mrs. Johnson was in a small, very small building, sort of an expanded office thing, and I knew where she was. So I brought a box of the books to her, and she looked at me and said, they didn't want to let you get near me, what did they? And so we stayed in touch after he died, though. What I eat for breakfast every morning was the recipe I got from her. And Mrs. Johnson called it breakfast stuff. It's in one of my wife's books, the recipe. And the only thing I can tell you, it's very healthy. Let's see, yogurt, raw oatmeal, pineapple, crushed pineapple or whatever, raw oat bran, a glass of milk, and I add raisins and pecan pieces.
Thank you, Jay. Any other questions? Yes.
I'm John Thompson, a citizen of Montgomery. My question is for Mr.
What that would be like after he'd spent 25 years really being the boss of his courtroom and this courthouse. He used to liken it to being a district court judge to rowing a rowboat by yourself. But I think he liked the appeals court. I think he was very effective in working with other judges there, and I think he would have done the same at the U.S. Supreme Court. I'm not sure. Jack Bass may be able to speak better than I can as to.
I think he was.
I believe he was.
At least.
I've got a little something. Let me find it here. It's very short.
My understanding was that some local congressman, that Nixon was prepared to appoint him.
I'm not sure.
Here's what happened. The Hugo Black, Justice Hugo Black was planning to retire, and he went to see Chief Justice Warren Burger and said he would like Frank Johnson to succeed him. Now, Frank Johnson had known Chief Justice Burger. He had met him at some of these Republican national conventions. And Burger sometimes came to Montgomery, and the two of them would go fishing in the Gulf. Johnson would call and get Bear Bryant to send up his private plane to pick him up. And then he heard that John Mitchell was, Attorney General John Mitchell was starting an investigation, and he said, that's the last I ever heard. Until some years passed, and the local congressman, William Dickinson, whose office was on the second floor, I think at a different floor of this courthouse, he came up to see Judge Johnson, and he told him that, he said, I want to apologize to you. When he said we, he was talking about the two other Republican congressmen from Alabama. When we heard that they were elected when Goldwater ran, he said, we got together and decided that if you were appointed to the Supreme Court, it would ruin us politically as far as Alabama was concerned. The three of us went to see John Mitchell. I want to confess to you what we did. And we told him it would hurt us politically and asked him not to do it. He, Dickinson, said, quote, if I had to do it over today, I wouldn't do it. We made a mistake, and I want to apologize. And this is Frank Johnson's words. And he said, and that's the first time I ever heard how close it was.
I had actually heard about that myself when it was in the works, and I had actually heard about Congressman. He was my congressman from Dothan. And Bobby. And then we're going to go up into the balcony.
Actually, I'm Bobby Siegel, a former law clerk. My co-clerk, Jack Billings, and I were actually in the Gulf with Judge Johnson and his brother, Jimmy Johnson, fishing. They were fishing. I wasn't very good at it. And on the radio, Judge got a call and said, you know, come to shore. The Chief Justice wants to speak to you. It's Chief Justice Berger. And then we didn't see Judge Johnson the rest of that night, but we went out drinking with Jimmy Johnson, who was known to have a drink or two. It still is. And he said that the Chief Justice told him that he was not in competition with anybody for the Supreme Court seat. He was the person, and Nixon was the president, and he was the person who was going to get the appointment. He was going to be decided up or down, and that the only thing that they were going to do was to consult with the Alabama Republicans. And starting the next day, we were driving back, and the capital punishment was a big issue then. And, of course, the big thing we wanted Jimmy to find out was if the judge went, were we going? So on the way back, driving back from the coast, the judge was asking us what we thought about capital punishment and the rationales challenging the constitutionality. Well, for about the next week, when he didn't hear anything about the Supreme Court, every day I was going in with a new theory why it was unconstitutional. The judge had already thought about each of those.
Yes, from the balcony.
Judge Thompson and the gentleman to your left, two questions or one related question. Could you discuss a little bit about the relationship between Judge Johnson and Judge Reeves, who was so important in getting those 3-2 votes early, or 2-1 votes early on? And second, this is a different time then than now. How did they deal with the public ostracization that apparently took place because of what they were doing, and how did they deal with that?
I'll answer the first question, and why don't you answer the second question. Judge Reeves, I am elated that you asked that question, because of all the men in history that I can think of who never got the credit they should have gotten, it is Judge Reeves. He was there shoulder to shoulder with Judge Johnson on all of those cases that he sat with him on. He was ostracized just like Judge Johnson. He had to live in this community just like Judge Johnson. And yet, I don't think anyone ever recognized what he and his family went through. When I first became a judge, Judge Godbold asked me to have lunch with him and Judge Reeves. I knew about Judge Reeves. I knew that he was truly an unsung hero. And by that time, he had started to wane mentally. I don't think that he ever knew who I was. But for 2 years, I took him to lunch. And for the last year, I took him by myself. We would leave this building. We would go to the Francis Cafeteria up on the hill, which was then open. He never said a word. But I thought that that duty, that obligation to Judge Reeves was comparable to any that I had as a judge. And I remember it fondly. He only came in for lunch, and it was to go to lunch. The reason I took him the last year is that Judge Godbold was not there, so I had to do it by myself. And we never uttered a word. Those are my memories of Judge Reeves.
One short other thing about Judge Reeves and Judge Johnson, and this is in Jack Bass's book, but I also heard it from Walter Turner, who clerked for Judge Johnson at the time of the Selma March. When the march actually went forward and had reached Montgomery, Judge Reeves invited Judge Johnson up to his chambers on the 5th floor of this building, where you could see the march coming in, and told him, Judge, this is your parade. I think you ought to have the best seat in the house to watch it. But I as far as how, I can't really speak to how Judge Reeves handled the ostracism. Judge Johnson, when I knew him, he was a very social person, but not social in the way that he liked going to clubs or whatever. He'd fishing was a big thing, and I think he felt like there was no effective way to ostracize him in that way. I remember one of my co-clerks, when I was clerking, she put on a Halloween costume party, and we invited the judge to come, and she said, Judge, you're going to have to wear a costume. He said, I'd be glad to do it. You got 2 choices. I have 2 costumes, the one I wear here at the office and the one I wear at home. Which one do you want me to come in?
Any other questions? Yes. Behind you, why don't we hear from you, then you, Deb. Yes, sir.
I'm her other half.
Oh, okay.
I'm Hal Strumlick. I'm a family physician. I live in New Jersey and work in the Bronx. And you alluded to this in your discussion, but I'm not sure who's the best one to answer this. But was the judge's decisions ever overturned at the higher courts, or what was it like when he was in the minority, and what was his experience in the appeals court where he was not in the majority, and it was not his rulings that ultimately hit the way?
Sure, and you may want to expand on this, but by the time I clerked for Judge Johnson, he'd received a number of awards. And there were a few of them hung up in his chambers where you could see, like a commencement, an honorary degree he'd received. But there is in his chambers, I don't know if it's still there, but there was it was almost like a big closet. And I remember once looking inside, and there was a little sort of daybed in there, and the walls were covered with all his honors. And I said, Judge, what's that? And he said, that's my ego room. He said, that's where I go when I get reversed. I go and sit in there for
I asked him that same question about being reversed, and he said, those are the only cases that you remember. Actually, I wanted to follow up on that to just show you what he felt about being reversed. One of my first controversial cases was when I declared the use of deadly force by the state of Alabama to be unconstitutional. There was no other district court in the country that had done that. He met me up in the hall upstairs, and he said, you may be reversed on this. Are you strong enough to take it? And I said, I think so. He said, well, you're going to get vilified in the press because they vilified you first and they're going to vilify you before when the three-judge court reverses you. I know who the judges are on the court. He says, but hold in there. I have the votes en banc. So he knew what it was like to be reversed. Yes, Deb.
I just wanted to make one comment about the ostracism because I remember what Judge Johnson said to me about it. He said, and in regards to Judge Reeves and himself, he said it was much harder for Judge Reeves to be ostracized because he was much more part of his community. And I think Judge Johnson, being from Winston County in North Alabama and being someone who liked to do things like fishing by himself, he said they can't ostracize me because I'm not part of the code. So he felt, I think it really hurt him less, but he also had sympathy for Judge Reeves, and I want to just say that in honor of Judge Reeves and what he went through.
Anyone else?
Yes.
Yes.
Gerald Bennett, Professor of Sociology, Alabama State University. In his book, Bus Ride to Justice, Attorney Gray is critical of Judge Johnson's decision to allow the construction of AUM. So my question is, I suppose, for Judge Thompson, would you concur with Attorney Gray's decision?
I knew someone would put me on the spot. To be candid with you, I was not involved in that case. I'm aware from a distance about the conflict as to whether AUM should have come into Montgomery. I know that Attorney Gray was very much involved in that. So I feel somewhat inadequate to respond to your question. I would like, however, to note that while Attorney Gray was critical of Judge Johnson in that regard, I don't think that there was a better lawyer who ever appeared before Judge Johnson than Mr. Gray. In fact, as many of you may not know, Attorney Gray was supposed to be sitting here today rather than me. It was Attorney Gray who was the first nominee for the judgeship that had been vacated by Judge Johnson. And I then replaced Attorney Gray, which in my own way I feel was unfortunate, primarily because Alabama had so few black attorneys that they had to turn to a 33-year-old to do the work once Mr. Gray stepped aside. And that, to me, was not right. Anyone else have a question? Yes.
I'm Brian Morgan. I worked for Governor Wallace, and he fully understood Judge Johnson's orders. Could you speak how, in his last term, could you speak how he convinced Judge Johnson to give up the voter rolls when Governor Wallace was a circuit judge in Barber and Bullitt counties?
Let me simply say it's covered in the book.
All right.
Yes.
I'm Natalie Bass, Jack's wife. I just wanted him to tell you how Jack Onassis came to edit this book. I wanted him to move that water bottle so that the...
That's mine.
Well, I didn't want to say you.
You did that very graciously.
So that the camera could take a picture of all three of you together. And also wanted him to say what Haldeman said about Mitchell's role in the appointments as opposed to Nixon having any opinions on it.
You may know more about Haldeman's role than I do. But no, I'd begun just going on the faculty at the University of Mississippi and a professor of journalism, and Gene Roberts was then managing editor of the New York Times. What was that question?
How you got Jackie Onassis?
Oh, okay. So anyway, I decided I was interested in doing this book, and had contacted my editor at Simon & Schuster, who edited Unlikely Heroes, and she seemed interested in doing it, but saw it kind of as a regional book. And so, but before that, what actually happened, I was working the summer after I went to Ole Miss. I was working as what was known as a professor intern at the Philadelphia Inquirer. Gene Roberts was the editor. He had been managing editor of the New York Times. He had been the Atlanta bureau chief during much of the civil rights period. And I'd been what is known as my first career as a reporter. I was a stringer for the Times, meaning a non-staff correspondent. And I'd get a story in almost every week, but in those days you didn't get a byline if you were a stringer, but you did get a little check at the end of the month, which was, I had 3 young children then, so it was useful in money. And so I wanted to come to the University of Alabama. Was having a program that summer on whatever anniversary it was of George Wallace's stand in the schoolhouse door. And I was interested in attending, and I couldn't figure out how to pay my airfare. And so this other professor intern says, well, why don't you write a story about how history will look at George Wallace and sell it to the Philadelphia Inquirer magazine, which was then a very significant publication. So I went to the editor, and they said, okay. And so they were going to pay me enough to cover the airfare. So I called Arthur Link, historian at Princeton, and I called John Hope Franklin and a couple of other historians. And, of course, I knew Judge Johnson. So I called him and asked him how he thought history would look at George Wallace. And he said, well, you just don't know. You just don't know. And spontaneously, I hadn't thought about it all spontaneously. I said, well, Judge, someday I might want to do a biography of you. He said, well, I wish you would. Well, so I didn't have any choice after that. And so about my first interview with him, I spent a full summer in Montgomery. In one of the first interviews, he said, who's going to edit this book? And I told him what I just told you, that Simon Schuster edited, but he said, Jacqueline Onassis would like to edit this book. So I called my agent. He said, send her a copy of book proposal. So she was the best editor I ever had. She was a hands-on editor. A friend of mine in New York said, find out who's going to be the copy editor for the book. So I asked one of her assistants, said, Mrs. Onassis. So I said, fine. And and I only met her twice, both for short periods of time, but I did ask her on the second time. I said, asked her how she became interested in Judge Johnson. And she gave me that look of, nobody's ever asked me that question before, and said, I guess it goes back to hearing Jack and Bobby talk about him in the White House.
We have time for one more question. Does anyone have a question?
He didn't answer my question about who as I recall it, Jack asked Haldeman.
Haldeman question?
He asked Haldeman who actually made the appointments to try to find out if Nixon had been influenced by the congressman, or if it was Mitchell that was influenced by the congressman. And Haldeman said that Mitchell made all of the appointments and all of the decisions about all of the judges, except for one friend of Haldeman's that was in Washington State, I guess, where Haldeman was from.
Thank you for the explanation.
Okay. If we don't have one, I do have a question for Peter that we'll end with. Martin Luther King said that the order that was issued by Judge Johnson in the aftermath of Bloody Sunday felt like, and I'm quoting, it was condemning the robber for getting robbed. Do you think that Judge Johnson's order was faulting both sides?
I think it'd be a mistake to think about it that way. As one clerk, Pat Sims, put it to me, when it came to notice and the opportunity to be heard, the judge was a true believer. He never granted one-sided relief without a full hearing and a full record. He believed in that both because he wanted to know what the facts were. He wanted to make them clear to the appellate court, too, so that there wouldn't be any question about his order being reversed. And I think in the case of the Selma order, he'd in fact already arranged, when he issued the order, he'd already called.
This is the order where he actually enjoined the march in many ways.
Right.
And so, of course, we have the later order where it went forward. And I just want to make that clear. We're talking about two different orders.
Yeah, and that later order came only after he'd heard a number of days of testimony, gathered evidence, written his opinion, was sure the president was going to enforce it. And even then, before he issued it, he had made the Fifth Circuit clear that it was coming. He'd arranged a time when they could hear it, and he had called the Montgomery airport and figured out when there were planes to get from Montgomery to New Orleans. So when he issued the order, he told the lawyers, if you want to challenge this, you got an hour to get to the airport and get up to New Orleans. There's a flight. And reportedly, one of the lawyers said, did you make reservations for it?
Well, thank you all very much, and I'd like to thank our panelists. Oh, I forgot one thing. After this, if you'd go to the Johnson Library, and many of you may not have seen the Johnson Library, and I hope that you will visit it, we have the actual original copy out for display of the memorandum opinion that is quoted in the movie Selma that Judge Johnson signed with his signature. And if you'd like to see the original copy, it's there for viewing. I will note that I told the courtroom clerk to make this opinion available for your viewing in its original form with signature. She said, unless I get an order from you, I will not comply. She said that I will not be responsible if it is damaged or in any way, and particularly if it's taken. I then issued an order to her to do it. And it is there for your viewing. And thank you very much. I'd like to thank our two panelists.